YouTube. Okay. Now, let's say there's a ballot measure there's a ballot measure in November of 2012. Let's say Minnesota, they have a marriage amendment down there, or up there comparatively, and let's say they approve that measure, which is very likely, but I really do hope that Minnesota does not. But for the sake of argument, they approve the marriage amendment that will limit recognition of civil marriage to gay and lesbian couples. It goes to court, and it's overturned by the state Supreme Court, and thus, even though it's in the state constitution, it's ruled unconstitutional and unenforceable. And then we have critics of this calling this judicial activism and ruling from the bench. And we have people like Focus on the Family, Michael Savage, saying that this is an outrage. The Constitution was meant to protect marriage, and it was supposed to do that, and the justices ran roughshod over 5 million voters who voted in favor of this amendment. And then we ask a major question. Can the will of the people be overturned? And should the will of the people ever be overturned, especially when it is something that has been passed to the people for a conclusive answer? Should the will of the people be above judicial review? Or should it be held in higher regard because the people voted it into the state constitution and it's a part of the state constitution now, so therefore it should be upheld instead of reversed? The will of the people cannot be above judicial review for numerous reasons. One, if we allow the will of the people to be above judicial review, that means that no matter what, even if the law is tyrannical, that it should still stand because of the people voting for it. However, this creates a terrible dilemma. In the event that the people pass a law that is unconstitutional, does that mean that they still have the right to make any kind of discriminatory law that they want to? Also, many people will argue that, well, making marriage between gay and lesbian couples should be prohibited by the state constitution, because, well, that's an area where you can have initiatives. Well, of course, because gay and lesbian people are not covered under Title VII, they can, in fact, be discriminated against in this manner. But should the will of the people be tossed out by judges? Yes. Simply because when a group of people act as their own legislature, the court should look at it as if it is the act of the legislature. Arkansas, when tossing out its ban on unmarried couples adopting, said this and cited Jeffrey versus Trevathan, and in fact I want to look up that case just to see what it was. More than likely it is about a ballot measure that was discriminatory. So when we take a look at the will of the people being adjudicated and possibly overturned by a court, many people believe that it is judicial activism or ruling from the bench. I have quite some issues with those words because of the fact that when one looks at the ruling and reads the ruling, if anybody does that anymore, you'll see the reasoning and you'll see exactly what they say. In Barnum versus Bryan, when watching, I think Pete LaBarbra's, when he looked through the ruling, he said that the court says that mother and fathers don't matter, and that religious opinion doesn't matter when it comes to homosexual marriage. But that was not the case. They were simply stating that a child raised by a gay or lesbian couple, there is no difference between a child raised with a heterosexual couple, with a married heterosexual couple, and a gay or lesbian couple who are not able to legally marry in the state at that time. And also, they did mention that religious objections are to gay and lesbians being able to marry. However, they must understand that this is a society where we have the freedom of religion. And I would like to add that there are religions that will in fact marry gay and lesbian couples. So should the will of the people be final and absolute? If it is, then it offends the very notion of constitutional review. If it's not, then that places the people as their own legislature, and that places not only the people as their own legislature, but the act of judicial review as a legislative, looking at it as a piece of legislation passed through the legislature, is quite appropriate for it. If it is constitutional and it advances a rational state interest and is narrowly tailored to meet that government interest, then of course it should stand. But if it is a bare intent to harm, like with Proposition 8, Amendment 2, Act 1 from Arkansas, then it should be overturned, and to not do so would offend the Constitution. And if we proclaim to uphold the Constitution, that does not mean that we uphold something in the Constitution because it is in the Constitution. In fact, a little note here: gay judges in states where there are marriage bans on the books have to take any case where a marriage ban is being challenged. They should take a look at the Constitution as a whole. And does the state constitution not only permit gay and lesbian couples to marry, but does the rest of the state constitution, is that consistent with this very amendment that we are challenging in court today? Most often you will find that the state constitutions not only give more than the federal one does, but it often enumerates the rights and enumerates the freedoms of the people of the state, and it does not abridge them. So the will of the people cannot and should not ever be above judicial review. To do so would not only offend the Constitution, but it would definitely place the democratic process and judicial review, I would say, into peril. Have a great day, YouTube.